Hello, I'm Katia Campbell here with the students of Metropolitan State University of Denver. Today we'd like to welcome you to the Solution Studio, a student production in front of and behind the camera. The Solution Studio is a new forum for Coloradans to speak face-to-face with elected officials about many of the biggest challenges facing not only Colorado, but our entire country. With that, we'd like to welcome and thank Attorney General Phil Weiser. Thank you so much for being here today and for spending this time with us.
It's an honor.
Yes. Before we start with our first challenge, the students of MSU Denver are going to take a moment to introduce themselves to you and to our viewing audience. So let's take it away.
My name is Tori Morris, and I'm a senior here at MSU Denver with a major in criminal justice and criminology and a minor in psychology. And over the summer, I was the MSU Denver intern in Senator Hickenlooper's Washington, D.C. office.
My name is Leah Dory. I am a junior here at MSU Denver, where I study political science with a minor in water studies and history. And I also got to represent MSU Denver in Washington, D.C. this summer in the office of Senator Michael Bennet.
I'm Jasmine Brond. I am a senior here at MSU Denver. My major is political science with a minor in legal studies. I was a policy and political intern in D.C. over the summer. Thank you for being here.
And thank you all for participating in Solution Studios today. We'll be presenting 4 challenge questions to our Attorney General, who will have up to 3 minutes to respond, and then we'll have a follow-up question round where you will have 60 seconds to respond. Attorney General Weiser, are you ready?
Bring it on.
All righty. Then let's get started. For our first challenge question, it will be read by Tori.
So in response to the Counterman decision, what new laws will you propose to the Colorado legislature or recommend to the U.S. Congress to protect victims of online stalking? For example, can we draw on the court's recognition that true threats are not considered free speech under the First Amendment as a means of providing protection for online stalking victims?
This is a personal one for me because I argued that case at the U.S. Supreme Court. And one of the hard parts was the court didn't take seriously enough the threats of online stalking. I am really concerned about victims of stalking. Stalking is sometimes called slow motion murder because people who are the victims of stalking are really vulnerable for other forms of crimes that could be murder, it could be assault. This is obviously something that happens in domestic violence. I don't believe the court's decision, while one we hadn't hoped for, requires new laws. Because what the court's decision calls on us to do is have a new jury instruction, which is a First Amendment standard, so that our law is now limited by the First Amendment. And we're working on this First Amendment jury instruction, which basically says that unless a stalker was reckless as to the harm to the victim and their experience of a physical threat, then they can't be found liable. We're concerned because if you have a delusional stalker or you have a devious stalker, we're worried that they're going to get away with it and they're not going to be held accountable under our stalking laws. So this ruling makes it harder. We're going to work hard with prosecutors around the state to develop the evidence necessary to meet this heightened standard so that even with this jury instruction requiring a higher state of mind than we used to have, we can still convict those engaging in dangerous and harmful crimes like stalking.
Thank you, Attorney General. We are going to take it back to our student panel now for follow-up questions. Who would like to go first?
Did you want to? Yeah. So what kinds of threats can now be deemed reckless and therefore unprotected? So are we not able to press criminal charges now based on concrete online threats just because the perpetrator can claim that they didn't intend to cause us harm?
Jasmine, you've put your finger on what makes this a troubling situation. If a perpetrator can say, I didn't mean anything by it, I was only joking, that is now a defense. Under the old rule, the rule that we defended, Colorado said if the statements, if the conduct, the series of statements are objectively threatening and indeed terrifying, that was enough, and you couldn't, as a defendant, say, I didn't mean anything by it. Now, the requirement is you have to show that the defendant was on notice as to how the victim experienced it. And if they can be found to have disregarded a known risk, then you can still find them reckless. But if they can say, I had no idea, couldn't have any idea, that becomes a viable defense.
All right. Thank you.
So I heard you saying that you want to work hard to continue to protect victims. What is in your power to do that?
Part of what I brought to the Attorney General's office is a much more hands-on, proactive approach. Okay. So what we're doing that's new is our criminal appeals prosecutors in our office are all acting as liaisons with every single district attorney office, so that when questions come up, even in real time, a prosecutor's office is investigating a case, and they're trying to determine, do we have enough evidence to meet this new legal standard? We're going to work to educate all district attorney's office what's required so they can meet this new heightened requirement. Okay. And we're going to be in constant communication. We're going to work to help develop the legal principles, help develop the cases, so that even with a heightened requirement, even with more burden of proof, we can still protect victims.
How can you test countermeasures as a discriminatory decision, since women are 4 times more likely to experience stalking than men?
I've been thinking a lot about this point, and I know we're going to talk some about equality issues. It's really big on my radar. There's no doubt in my mind that if Justice Ginsburg were on this court, and I had the benefit of clerking for her, she would have been a voice to say, wait a minute, stalking is a crime generally committed by men against women. It's a crime of power. And when you make it harder to protect victims of stalking, you make it more likely that those victims, mostly women, can be exposed to physical harm. So there's a short answer to what we do in the short term and a longer answer we do in the long term. The short answer in the short term is we work with prosecutors, we develop the proof necessary to meet this heightened standard. But the longer term is, to your point, we need to continue developing the evidence, developing the arguments, so that perhaps we can get the Supreme Court to change its standard. Currently, this standard, the recklessness standard, is a heightened First Amendment standard that is the same type of standard that newspapers get when they are faced with civil lawsuits from public officials, defamation lawsuits under Times versus Sullivan. I don't believe stalking perpetrators deserve the same type of protection that newspapers do under the First Amendment. So I'm concerned by this. In the short term, we're going to work to bring cases. In the longer term, we got to bring these equality issues to the fore, because not protecting stalking victims absolutely is going to hurt women, and it's going to hurt victims of domestic violence.
It looks like it's time for challenge 2. Let's go to Leah.
The 303 creative decision gives businesses engaged in expressive activities a free speech exemption to public accommodation laws designed to prevent discrimination. You have stated the Supreme Court's opinion represents a radical departure from decades of court precedent and fails to uphold the principle of equal justice under law, inscribed on the U.S. Supreme Court building. If so, how can Colorado protect classes of people such as LGBTQ+ from future discrimination, given this ruling?
So Leah, you've now added an insult on top of the prior injury that I just was having to reflect on. We lost 2 cases this year at the Supreme Court. In both cases, the Supreme Court adopted views of the First Amendment that I strongly disagree with. We touched on the first one and the people who are going to be harmed, particularly women, particularly victims of domestic violence and stalking. Now you ask me about 303 creative, and the people going to be harmed there are also numerous. It's not just LGBTQ individuals. I'm going to talk about that, but I also want to make sure we talk about all the other groups that could be harmed by this 303 creative decision. For those who didn't focus on this case, it involved what I'm going to call made-up facts, because there wasn't an actual controversy at the time. There was someone who said, hypothetically, I'd like to create wedding websites for same-sex couples. I'd like to create wedding websites, but I don't want to create them for same-sex couples. And I'm afraid to get into the business because I'm afraid I'm going to be sued by the Colorado Civil Rights Commission, who enforces the Colorado anti-discrimination law. Colorado has an anti-discrimination act that has what is known as a public accommodations provision. That provision says you open your doors to the public, you got to serve everybody. Well, this website developer said, I don't want to serve everybody because I don't believe that same-sex couples should be able to get married. The Supreme Court created this exemption. This exemption says if you can state you've got a freedom of expression concern, then you basically can get an exemption from the public accommodation laws. Our challenge now, kind of like the challenge of the Counterman case, is how do we limit the damage by looking to make sure that our civil rights laws can be enforced as robustly as possible, and that those seeking exemptions have as narrow a loophole from our civil rights laws as possible. It's a similar sort of answer to my first question. We are the lawyers for the Colorado Civil Rights Commission. We are going to work hard, and we're going to make sure that we can do the best to keep enforcing these laws, even with this exemption.
Right.
So how exactly are you going to navigate narrowing that sphere to reduce the harm?
The challenge is there's going to be a lot of pressure to widen that sphere in all sorts of ways. So our position is going to be to get these cases as well supported as possible and to make sure that anyone who says, I've got this interest in not serving same-sex couples, or it could be taking photographs of women, or it could be selling Bibles to religious groups they don't believe in, that we work on the facts and that we make sure that anyone who makes these claims, it's a bona fide claim, and that kind of like the Counterman case, we have to also play the long game. I believe this is wrongly decided and the Supreme Court needs to reverse this ruling. That's not going to happen soon, but over the longer term, we're going to make that case.
Thank you, A.G. Weiser. Let's go to our student panel for follow-ups once again, allowing our students to choose amongst themselves.
So you kind of touched on it a bit. So to be pushing back against this federal ruling, what exactly are you able to do, and what is that going to look like for Colorado inhabitants?
We're going to stand our ground to the best of our ability, work to make this exemption as narrow as possible, work to develop the compelling reasons for overturning the 3-3 decision. The painful reality right now, somewhat like the Dobbs decision overturning Roe versus Wade, is this decision, the 3-3 decision, will do real harm in the short term.
Speaking of things that your office can do now, do you think that there's a law that you can advocate for that would clarify when a religious belief stops being religious belief and turns into discrimination or prejudice against someone else?
Unfortunately, because we're dealing with First Amendment rulings by the Supreme Court, I don't know that a law passed by our legislature is going to help. What we can do is make sure that we develop the legal advice that has the most protective of civil rights interpretation that we can offer, and that ensures that anyone trying to get an exemption has the highest possible burden to get it.
So what I hear you saying is you're kind of backed against a wall and you're trying to just hold the standard as high as you can.
Correct.
But is there anything else that you can do to help protect Coloradans?
So one of the things that is important to recognize, it's not only about the legal rulings, it's about we as a society and our social norms. What I'm committed to doing is a message that we don't discriminate here in Colorado based on who you love or your gender or your color of your skin. We serve everyone. We may have limits in enforcing that as a matter of law, but as a matter of our social norms, I'm going to fight hard for that principle.
All right, did we get all of the follow-up? We have a little bit of time left.
I would just, is there any other angle or capacity in which you have to see that through?
Here's one thing I want to say. I mentioned before, this case, 3-3 Creative, is not only limiting LGBTQ plus rights. There are going to be other cases, and I believe as we deal with those cases, that's going to lead the courts to potentially see this as a more threatening ruling than some are today. For example, if you are a photographer in a mall and you say, I don't believe women should be in the workplace, I'm not going to take pictures of women, you can say that's your expressive interest in not taking pictures of women in the workplace. I don't know that Coloradans or Americans are going to be comfortable setting back women's rights in the workplace because they can't get professional headshots or other resume support. We, as a society, need to continue advocating for equality. As I mentioned, I work for Justice Ginsburg, who did that extraordinarily well. So finding the right cases that push back on this is work that I'm committed to doing as well.
Are there any cases kind of coming through the pipeline that you already have your eye on for that?
Not yet, but that's something that is an important idea. We need to keep our eyes out. If you're out there and you're a victim of discrimination and you're looking hard at what can I do, I want you to know our office protects the civil rights of all Coloradans. And please be in touch with us, whether or not you've been harmed as a worker, as a citizen, or as a consumer. We're here for you.
All right, so another follow-up. We still have some time. This is a really great discussion.
I know you kind of talked about what your office is doing at the moment. Is there anything that we can do as citizens in terms of this ruling?
This is an important point, and it is the flip side of what I said. I said we need a social norm where all of us commit to a principle that everyone deserves to be served equally. If there are businesses out there that say we're not going to serve, and you can fill in any group, Jews, Muslims, people who have disabilities, gays, blacks, any individual person who says, wait a minute, it's the color of my skin or who I love, it shouldn't matter. We all can say, we're not going to business that doesn't serve everybody. So we all as consumers have a voice. We all also can work together to make sure that when these cases that come down the pike are there, we raise awareness about this. I believe in equality for everybody. That's been work that has been done. I know this case is a setback, but it can be just a temporary setback.
Would you be able to share an example with us of a form of discrimination that would be no longer protected due to Creative 303?
Unfortunately, there are more than a few. I made a reference to it. I want to explain this. If I own a bookshop that I sell religious texts, and that I say I choose the books to sell based on my expressive interest, and I actually need to choose who to sell them to. I don't want to sell books to, and you can fill in a religion that the seller says is not a legitimate religion. That's a problem, that people could go to a public shop that's open to the public and be told, I'm sorry, we don't serve you. In the dissent, there was a very important point made. It wasn't just that Jackie Robinson, when he went to the South on the Brooklyn Dodgers, got a place to stay. He needed to be able to stay in the same place that his teammates did, because being turned away from any public business based on who you are is something that we don't do in the United States of America anymore, and we need to make sure that this loophole is as limited as possible, is ultimately over.
Are you willing to make Colorado sort of a fighting ground to push back against that, given the right case?
We already are, and we in Colorado believe in equal rights for everyone. I want to celebrate a history here in Colorado. 1992, we passed a law that said civil rights protections can't be afforded to gays and lesbians. It's called Amendment 2. That went up to the U.S. Supreme Court, and the Supreme Court overruled it. At the time, we were called the hate state for having passed that law. We've elected the first openly gay governor in the United States. We are proudly standing with everybody in a Colorado for all, so absolutely.
Excellent. Thank you. Great discussion. It's now time to move to our third challenge.
Today, as a practical matter, to participate in the public square, Americans must use social media platforms, which are owned by billionaires whose profit models depend on selling their data. The Colorado Privacy Act has been newly implemented into state law with the purpose of protecting online consumer data. The act states that it provides consumers the right to access, correct, and delete personal data and the right to opt out not only of the sale of personal data, but also of the collection and use of personal data. What further legislation or other measures can you propose to further protect Colorado's online users from these companies exploiting their personal digital footprint?
Well, there's a lot in that, and I'd love to talk more about social media because it's an area that I'm very focused on. The point you just started with, it's worth celebrating this. Colorado is the third state in our nation who passed a comprehensive data privacy law. Here's what that law means. If your data is being collected without your knowledge, without your awareness, or without you agreeing, you can say, I don't want you keeping my data. I don't want you selling my data. And by the way, if you want to look at what data has been collected, you can look at it. You can correct it. You can delete it. So you have rights. It's important that we make sure consumers know about their rights and businesses following this law. As to whether or not we need more changes on this law, my answer is I want to see how it's implemented, and if there are limits, if there are failings, I'll be the first to say, you know what, let's go back and fix it. One of the tools we have that makes it less necessary to get a new law is we have a rulemaking procedure so we can keep adopting new rules that implement the law so that as technology changes or as we learn about certain loopholes, we can address them through rulemaking.
Thank you, Mr. Weiser. So let's go ahead and give some follow-up questions.
That's really awesome to hear that the law is, it's adaptable like that. Could you speak to, is that law a model for the rest of the country? Did you work in partnership with California or any of the other states to help create that?
Let me take a couple of points. Yes, we work with other states, and I can't keep track anymore how many states have this law. We were number 3, but I think we're now like up to 12 or 13 states or something like that. So more and more states keep passing. I do believe if you ask people which law is the model, obviously I'm biased here, they're going to say Colorado. Let me tell you why it's the model. Because Colorado worked on this law in a thoughtful, open-minded, and bipartisan way. When that law passed our state Senate, which is where it started, it got unanimous support. Because we gave room for everyone at the table to say, what are you concerned about? Could there be unintended consequences? And we had a really rigorous, thoughtful, collaborative process. So we passed what I believe is a great law. We have a rulemaking process that we also were very thoughtful, collaborative, and extensive. We had several rounds. We started informally with ideas. We put out rules for people to look at, to give us comments on. We then adopted those. And finally, Colorado has what I'd call a principle-based approach, which means we start on what principles we're trying to advance, and we're not getting too prescriptive about technology, some of which can become antiquated.
So in terms of like companies that would like break the Colorado Privacy Act, are there any penalty or punishments that exist right now, or are there any legislative repercussions that could be put into place already that are strengthened or could be introduced?
We do have very significant penalties for those who violate the law. The way we're approaching this right now is we're going after what I'm going to call those who are more willfully violating the law, as opposed to those who might have what, depends on what sport you like, if it's basketball, ticky-tack fouls, or tennis, foot faults. So we're looking for people who are thumbing their nose at the law, refusing to comply, and we're going to go after them, and there will be penalties there. We're also educating businesses on what their responsibilities are, because right now businesses have to do regular data assessments. Too many businesses keep too much data for too long that they don't need, and then, lo and behold, it gets in the wrong hands. This data assessment requirement is going to enable businesses to think, you know what, we don't need to collect this type of data, or we shouldn't keep it for this long, or these people shouldn't have access to it. That's going to be, to my mind, a big impact of this law, and it's just getting started.
So to be clear, this data assessment will be required of Google, Snapchat, Facebook, or Meta if they want to be in Colorado.
Yes, every company operating in Colorado collects data, including those big behemoths, have to follow this law. And they've got to ask themselves, what data am I collecting? Am I telling people about the data I'm collecting? Can they have a chance to opt out and not have it collected? And are they keeping it for too long or giving it access to too many people? We believe this is going to materially help consumers.
So to kind of pivot, I know that you've expressed a lot of concern about TikTok and its negative influences on like mental health of teenagers, specifically women. But kind of taking that and thinking about like the foreign interference aspect, since TikTok is owned by a Chinese company, U.S. lawmakers were recently expressing some concern over the protection of data, et cetera, but then a lot of those bills stopped and haven't really gone through. But how do you recommend that we protect ourselves from foreign influence and propaganda online?
I first want to start underlining your question and the point that you started with. The mental health of our kids, particularly girls, is worse now than perhaps it has ever been. The Surgeon General has called this a crisis. When you look at young girls and rates of suicide, emergency room visits and self-harm, it's alarming. When you compare it even to a decade ago, it's clear something has happened. The number one answer of what's happened is social media, and the reason is because companies like TikTok, like Instagram, there are others obviously, they have these algorithms so that when someone looks on TikTok or Instagram for how to lose weight, they can get content related to all sorts of eating disorders, self-harm, even suicide. They can get content that takes them down a dark hole, doesn't give them adequate time to sleep at night. So we are really concerned, and we are seriously investigating both Instagram and TikTok with an eye to how do we protect our kids. You raise another question, which is, what about the fact that TikTok is a foreign company and may engage in all sorts of practices that are problematic? The reality for them is, if they operate in Colorado, and I'm investigating with every single state attorney general, we're leading it here in Colorado, they have to follow our rules. Doesn't matter where the headquarters. They're marketing to our customers. They have to follow our rules. We have rules to protect kids, including a law called the Child Online Privacy Protection Act, including our consumer protection laws here in Colorado. So I'm going to enforce those laws against anyone, whether they're a U.S. company or a foreign company. And I think we all have to take seriously, as people who care about kids, how we protect them. This oversight is just one step. I'm interested in other measures to protect our kids' mental health.
Like you stated, social media can definitely have an impact on young girls, but can also have an impact in terms of like disinformation being spread to people. So can you describe a lawsuit that holds social media companies accountable to make sure that information during a time of crisis, such as an extreme weather disaster or political violence, is not bot-driven disinformation?
That's a question that gets us into delicate First Amendment territory. And one of the problems we have right now is we haven't had any federal oversight over these social media platforms. And I am looking at that question, what sorts of measures can withstand First Amendment attacks that would provide transparency, would provide awareness about what type of content moderation protects consumers from bots, from other misinformation campaigns. And I'm not sure I've got the answer fully developed on this. You're right to be focusing on it, thinking about it. I'll give you a partial answer, which is not a regulatory answer, but it's an education answer. One of the things we have to take seriously in colleges, in high schools, educating students for citizenship at a time when they're getting more and more misinformation than ever before. I grew up in a much easier time to be a citizen. We had well-developed journalistic entities that closely evaluated content by asking, is it true? But on social media, you can have content being pushed out that is completely untrue to inflame people and misinform them. And we have to prepare everyone for that reality because it's all around us.
All right. Go ahead. Yes.
And do you think this new data privacy law is enough to do all these things that you talk about?
The problem with any law is it can't do everything. So the data privacy law helps on one important strand. It helps consumers get control of their information. It holds companies accountable for misusing information and provides measures to make it harder for companies to misuse information. That's only a start. As for holding social media companies accountable, I'm investigating them under a different law that we are looking at how we protect consumers. As for educating citizens, that's yet a different project.
All right, thank you. And now for our fourth and final challenge question.
So Colorado has seen mass shootings in schools, nightclubs, grocery stores, and movie theaters. This past legislative session, the Colorado legislature passed and the governor signed legislation to expand the application of red flag laws. Recently, the Supreme Court announced they would take up U.S. versus Rahimi, a Second Amendment challenge. Will you seek to have Colorado participate in this case through submitting or joining an amicus curiae brief in that case to protect Coloradans from gun violence? And if so, what arguments would such a brief make?
We're touching on a lot of topics around the Supreme Court, and for a good reason. Our current Supreme Court, in the Counterman case we talked about, in the 3-3 creative case, I referenced the Dobbs decision, and now we're talking about the state of our Second Amendment jurisprudence, Supreme Court cases. I'm scared because the Supreme Court in this Bruin decision said Second Amendment rights are viewed from the lens of what was the state of play in 1791. The case you just mentioned, a case out of the Fifth Circuit, involves a federal law that says victims of domestic violence should not have to fear that their perpetrators have access to firearms, and thus the federal law would remove firearms from a domestic violence perpetrator. We got the same law here in Colorado. I fought for that law. And you're right to say that law is now vulnerable to a Supreme Court that may or may not recognize the consequences of striking down this law. So yes, I'm all in. We will be part of an amicus brief on this case. We're going to put forward arguments that go basically like this. It's similar to what you noted about stalking. Domestic violence is generally committed by men against women. This is October, Domestic Violence Awareness Month. And unfortunately, there's not enough awareness about domestic violence. We put out a report every year, Domestic Violence Fatality Review Board report, and we talk about all the people who died in domestic violence deaths from the year before. Last year, we made a point loud and clear. Most of those deaths are firearms related. You make it harder to remove firearms from domestic violence perpetrators, more people are going to die, more women are going to die. And I recognize domestic violence was not a crime in 1791, and so you could take a narrow view that the Second Amendment doesn't stop domestic violence perpetrators from having access to a firearm. That would be deeply misguided. We're going to do our very best to persuade the Supreme Court to allow this law to stand, and other laws like the red flag law you mentioned. We need that law to pass constitutional muster, because if we lose that tool, then that's going to expose other people to potentially dying because we can't remove firearms from people who are a significant risk to themselves or others.
So, sorry.
Oh, yeah.
If this is deemed unconstitutional, what ways will we be able to protect ourselves still and protect other individuals who are in vulnerable situations?
I hate to think about this scenario because this tool, removing firearms from people who are dangerous, is, to my mind, the best tool. But your question is, what if we lose this case and we don't have that tool? That tool is now invalidated. Here's what I would say. All of us can and should support victims of domestic violence. There's a lot of fear, a lot of stigma. Victims will often not admit that they are suffering. We need more resources to help people who are victims get access to protective services like the Rose Andem Center here in Denver, which is a family justice resource center. If people who are suffering domestic violence have those protections, they can be in places, maybe shelters, maybe other places, where the perpetrator doesn't know where they are, and we have to create mechanisms to protect victims even when they're testifying so they can't be followed, because they are at risk. We know that those who commit domestic violence often will keep doing it until they may kill a victim.
So what exactly is in your power if the Supreme Court does rule to allow domestic violence people to have guns, aside from these other resources that you've listed?
We will look to explore what laws we could pass. So one of the issues that sometimes happens is the Supreme Court invalidates a law on certain reasons. We can pass a different law that maybe can withstand that legal test. So I'd have to see what the opinion ultimately says, but I am deeply committed to gun safety efforts and ensuring that we can find a way to withstand Second Amendment challenges. If that means we have to go back and recraft certain laws, we'll work with the legislature to do that. On the point about supporting victims of domestic violence, our office has put out a call for some grant applications. We're going to be making some grant applications to support domestic violence victims. We're going to be calling awareness to domestic violence. I'm going to keep that work going strongly, whether or not we have what we think is a central tool, removing weapons from people who commit these crimes.
Like the question stated, we know that Colorado has kind of expanded the red flag laws. So what specifically has your office done to protect citizens from gun control in Colorado?
Let me talk about a few things we've done. Obviously, we've been defending these laws in the face of Second Amendment challenges, and we're committed to doing that. We've continued to prevail in those cases, and it's important to remain nervous because the Supreme Court has decided this Bruin case that could open the doors to more challenges. Second, we've worked hard in the case of domestic violence to advocate for new laws and to make sure those laws are enforced. In terms of enforcing those laws, we've been developing more and more tools to explain to people who can use the domestic violence law or the red flag law of how we get firearms out of the hands of people who are dangerous. We did a report, for example, the first year of the red flag law, explaining its impacts, explaining its value. We've also done some voluntary measures to encourage safe storage, because a lot of times when you think about youth violence, particularly suicide, and there are more suicide deaths from gun violence than there are homicide deaths, safe storage makes a difference, because a lot of times people get access to these guns from their parents because they're not secured. So we've pushed out the basic message: store your weapon securely.
So if there is a challenge then to these red flag laws, will that also prohibit people with like a mental health record? If we were to try to prohibit them from having access to firearms, would that still be deemed unconstitutional, therefore unenforceable?
I'm really concerned about that.
Yeah.
This case at the Supreme Court involves a specific type of law protecting victims of domestic violence. If this law isn't invalidated, there's a real risk the Supreme Court is willing to invalidate red flag laws. You noted this point, and I'll underline it. Red flag laws can take firearms away from people who are unstable because they're in a situation where they might be at some type of personal crisis. And I've talked to parents who have said, I need a red flag law because if I've got a child who is threatening suicide, I don't want that individual, I don't want my child to have access to a firearm. The reason we have this law in Colorado, actually, it's named after Zachary Parrish, who was a deputy in Douglas County. They were dealing with someone in Douglas County struggling with real mental illness. They knew he had lots of weapons. They never removed his weapons. He ended up killing Zachary Parrish. So I'm afraid of that scenario you note. If we lose this case in the Supreme Court this year, then the next question is, will we have our red flag law invalidated? And then will that mean that people who might be really struggling with mental illness have free access to firearms? I worry about that. And here's what's worth noting. The earlier Second Amendment case, before Bruin, a case called Heller, specifically said government can and should limit access to firearms. The right to bear arms is not absolute, and we can limit it to people who commit crimes or people who have mental illness. That's what the red flag law does. I'm going to do my best to defend it.
We have time for one more.
In the event that the Supreme Court doesn't allow domestic violence individuals to have guns, are there any laws you would introduce to make Colorado even more robust? Is anything lacking?
You raise a very important question, and I will say my mindset about gun safety is a continuous improvement mindset. Since I've become Attorney General, we've passed red flag laws, we've passed waiting periods, we've passed heightened laws protecting victims of domestic violence, we passed an age limit, we previously had a high magazine capacity ban, we've also have a background check that's robust. Here's the law we really need: federal action. Because right now, even if we've got a great background check law in Colorado, someone could go to a gun show in Wyoming and buy a gun there without the types of protections we have here in Colorado. So if you say to me, what's your top gun safety priority? Federal access, federal legislation that can limit access. Obviously, robust background check is an obvious area that we need federal action. I'd love to see them follow Colorado's model on other areas as well.
It looks like we are out of time. I want to thank our student panelists.
Thank you for having us today and allowing us to ask you some questions. I also want to thank MSU Denver for this amazing opportunity for us. And just a huge thank you for everyone watching and supporting us tonight.
Yeah, I would echo that. Thank you to everybody watching, and thank you, Attorney General Weiser, for being here.
Yeah, thank you so much. This has been truly incredible. And then also thank you, MSU Denver, for providing us with these opportunities to meet people such as yourself. And thank you, Dr. Davidson, for creating the Public Service Institute in DC. So thank you.
And I also want to thank you, Attorney General Phil Weiser.
I want to thank you all for having me join you at what has been a very meaningful and engaging conversation. We need more discourse about the state of our democracy, how we protect those who are most vulnerable. This has been really a fabulous conversation. I appreciate it.
Thank you for joining us. We want to thank our partners for making all of this possible, which includes the Institute for Public Service at MSU Denver, the League of Women Voters of Colorado, the Colorado Latino Leadership Advocacy and Research Organization, also known as CLARA, and New Voice Strategies. Thanks for watching and have a great night.